Hello, my name is Jeff Gottlieb. I'm the owner of the law firm of Jeffrey Gottlieb. To begin with, we are today discussing the concept of a conservatorship for a developmentally disabled child or adult. Usually it's an adult over the age of 18 where we do conservatorships, or it's a 17-year-old that's about to become 18 in several months. A little bit about ourselves. Our office is dedicated to families that have a developmentally disabled child or a developmentally disabled adult. Usually that's autism with various levels of intellectual capacity, Down syndrome, and individuals who have a genetic condition which unfortunately leads to a form of intellectual disability. As to our services, we provide the following. We provide conservatorships, helping people obtain those. Sometimes they're contested, most often they're not contested. Contested are usually between former spouses who don't get along and they just want to fight it out, which is very unfortunate because they're very costly proceedings to complete, very similar to a contested custody case in family law. We also do trust and special needs trust on behalf of families that want to do estate planning, specifically targeting the needs of their developmentally disabled child. We also do SSI appeals, regional center appeals, where there's a wrongful denial of eligibility as a consumer. We don't do we don't do appeals for services where someone is already a current consumer of the regional center. We also do special education services. We do family law involving a disabled child, and we have a long history of working on adult child support cases where there's a developmentally disabled child. So that's generally what we do. We've been doing this for at least 2 decades. I'm not going to count the exact number of years right now, but it's been in excess, I believe, of 2 decades. So we have a lot of experience there, and now let's move on to a conservatorship. A conservatorship, specifically for a developmentally disabled individual, is in recognition that legally, when someone turns 18, there's a general legal presumption that the individual is able to make decisions on behalf of themselves. Well, with developmentally disabled individuals, that's quite often not true. There are some hybrid situations where someone can make some decisions, but not other decisions. May be able to make employment decisions, can't make medical decisions. I had to think about that for a second. So anyway, when a person becomes 18, the presumption is there. The way you overcome that presumption by convincing evidence is to present to the court the clinical information and lots of pleadings, about 50 pages of pleadings have to be presented to the court, where almost always in our situations they're approved. Very rarely is a conservatorship not approved when we get involved in it. So I'm trying to think of giving you the easiest way to understand this in terms of the 18-year-old and the 17-year-old that I just talked about. The easiest way to understand this is that a conservatorship for a parent of a disabled child gives you back essentially the powers and authorities you had when the child was a minor. So when a child is 5 years old, disabled or otherwise, you as a parent or parents can make decisions, medical decisions, educational decisions, where your child lives at 5 years old, all types of decisions that can be made, contract decisions, which typically does not include a 5-year-old but can be on behalf of a 5-year-old anyway. So what conservatorship does is restore those powers, essentially, oversimplification, but it works here, that you had when your child was a minor, even though the child may be now over the age of 18. That's the easiest way of understanding what is a conservatorship. Gives you the authority back you had when the child was a minor. So that's the simplicity part of it. For individuals in the state of California, there's up to 7 powers, and all 7 of these powers used to be automatically granted. Then it's got down, in some counties, down to 5 and even 4. So I want to let you know what the 7 are. I'm going to use my fingers to count those powers. The first one is medical, number 1. Number 2 is education. That would include IEPs and also to some extent the IPPs, I should say, individual program plans for the regional center, the annual reviews. So that's number 2. Number 3 is where the adult child, because conservatorship is only over adult individuals, where the adult child will live. In the legal language, they call it to fix the residence. It doesn't mean to repair the residence. It means to choose where that individual will live at any course of time. The next one is contracting. You will have the ability typically to contract on behalf of your disabled child, if that's what it is. It could be a disabled sibling as well, but usually 90% of the cases involve children, adult children, I should say. So you get to sign contracts on behalf of your disabled child. Now, contracts are difficult for anyone to understand quite often, even for an attorney buying a car from a car lot. However, a disabled individual who is, let's say, nonverbal, autistic, nonverbal, intellectually disabled, that child or adult cannot ask any questions that would be relevant because they're severely intellectually disabled cognitively. So you get to make those decisions of a contract on behalf of the disabled person. That's number 4. Number 5 would be access to confidential records. This is extremely important. You can't make medical decisions, which was our number 1 power, I believe. You cannot make medical decisions if you don't have access to healthcare records, for example. So you will have access to all records, including, most importantly, otherwise confidential records. Next two are sort of controversial just because many counties or court systems are taking away those powers. One is over marriage. There are still counties out there that will grant that power to a parent. Don't ask me why they allow this. A lot of courts will just do it as a matter of course. I have some concerns about that, but quite often the regional centers is leading the charge in this, and the courts are going along with it, where regional centers will not recommend marriage. The next one is sexual and social contacts. Quite often that is increasingly not granted by the courts. There's still a number of courts that grant it. I don't want to name them in particular because they may take it away shortly because of the pressures from the regional center. So those are the 7 powers. Now there's a term of art, legal art, I should say, term used for describing what I just called the 7 powers. It's called a limited conservatorship. However, people will come to me quite often and say, well, I want a full conservatorship. I don't want a limited conservatorship. Well, limited is a very strange term to use because that's what people think, they're being limited. If you get all 7 powers, you have everything that you need for the conservatorship over the person, which is what you're looking for. You could get a conservatorship of the state, but there has to be cash, not cash flow necessarily, but could be, but it has to be cash. There has to be assets such as stocks or a home. Most of these individuals who get their conservatorships, even from wealthy parents, they have no assets. They're essentially in poverty. They have no assets to control, which is not that unusual from an 18-year-old anyway. So what may happen is you may have an individual who is relatively high functioning, cannot make medical decisions. So the parents may only go for 2 or 3 powers. That would be the power over medical, access to confidential records, and to contract. Because in medical decision making, there's always implicit, I shouldn't say always, most often implicit, the need to contract. So for example, if you're with Kaiser, when you sign up, you may sign a waiver for taking a case to court. It has to go through mediation and arbitration, which is to Kaiser's advantage, by the way. So you may only have 3 powers. So a conservatorship becomes limited only by the nuance that you have a very high functioning child and that you only need a few powers. And for example, the child will say, adult child, I want to marry who I want to marry. I want to have sex with whomever I want to have sex with. Hopefully that may not always be fine with you. And I want to be able to choose my friends. And they're able to articulate that, which shows that you have a relatively high functioning disabled individual who is disabled only in a few areas of deficits. So that's what this conservatorship is called for a cognitively, or I should say, a developmentally disabled individual, which is usually autism, Down syndrome, or some other condition, genetic condition often, that leads to intellectual disability. And of course, there's a wide range spectrum for the autism, and there's a wide range of capacity and competency of even Down syndrome. There's stereotypes of the Down syndrome. In my practice, I have found very high functioning Down syndrome kids, adults, and I call them all kids. And there's been some that are extremely low functioning. So it truly is a spectrum. All of these developmentally disabled individuals are on a spectrum. So that is the powers that can be granted. Let me see what the next item will be, the process. So let's go through the process briefly. 1, you will probably retain an attorney. If you don't, there's some risk to that, but that's your call. 1 is you need to file paperwork, or on your behalf, an attorney will file pleadings, it's called, not actually paperwork, but pleadings to plead your case. That is typically 50 plus pages for a limited conservatorship, or you could call it special needs conservatorship. So that's 50 plus pages. A lot of the pleadings refer to specific code sections in probate where the conservatorships lie as part of the legal process is in the probate code and is handled by the probate courts. So what is the process? You retain an attorney, let's say that takes place hypothetically. Attorney gathers information, files all these pleadings. It takes us usually 3 or 4 weeks to get it out. Some attorneys are much quicker than us, but we go through IEPs, IPPs, psychoeducation analysis, evaluation reports, I should say, and anything that helps us understand the individual, because we don't want to become flat-footed in court where the judge asks a simple question that's a clinical question about the particular individual before him to be granted or denied a conservatorship, and your attorney doesn't know anything about the nuances, the deficits of that particular individual. So anyway, so that gets filed. You get a court date anywhere from a few days to 1 or 2 weeks later. Usually now with the internet and electronic filing, it could be a few days later. Then nothing happens. It's radio silent for several months. Then what happens, starting about 30 days before the hearing, which will be typically a 10-minute hearing, even though you may be at court for 3 hours, hopefully you come up first, but there's sometimes 20, 30, 40. I've even had close to 50 cases that I'm competing against to get our case heard. But the actual proceeding is anywhere from 10 minutes to 20 minutes, typically only about 10 minutes as everything is done properly beforehand. So what will happen? So before the hearing, you will have got from your medical doctor or licensed clinical psychologist a medical capacity form declaration that has to be filled out by that individual and submitted to the court. It's a 3-page document. It's not difficult for a clinician to fill out. A few refuse to fill it out because they're confused about what a conservatorship is and they're worried about liability, which is not an issue, but I could understand physicians being worried about that. So there's a medical capacity declaration that should definitely be filled out 30 days before the hearing. By the way, the hearing usually takes place between 3 and 5 or 6 months after you or your attorney has filed all the pleadings, which I call paperwork before. So once all the pleadings are done, you're in court anywhere between 3 months and 5 or 6 months later on. It varies from county to county quite dramatically, as well as by the court docket and how busy the courts are at that particular time in their countering. So you filed the paperwork, the pleadings for the conservatorship. You got this medical capacity declaration form. The regional center will file, usually within a week or two of the hearing, which is again 3 to 5 or 6 months later, will file a recommendation as to whether or not there should be a conservatorship and whether or not they support who's been nominated to be the conservator or co-conservators. The court will have an investigator that goes out and makes a recommendation. That person works for the court. Separately, an attorney, and in some counties it's Orange County's public defender if you're residing in Orange County. Most other counties it's a private attorney hired by the court. Each individual will make a recommendation as to what, similar to what the regional center will hopefully make a positive recommendation about. And that is whether or not a conservatorship is merited, should be granted. That for us, that's never a problem because I think at least we do a good job. So hopefully that's the reason in drafting our pleadings concisely as we can to inform the court what's going on. But that person is quite often, for most counties, is a private attorney hired. You do not pay for that attorney unless there's a conservatorship of the state. That for the developmentally disabled, that's very rare to have a conservatorship of the state. If there's, you will see that quite often with the elderly, where they own a home, there's a pension, there's plenty of assets to pay for the attorney. However, there is no responsibility on your part, individual as co-conservators or conservator, to pay for the attorney who will represent your child. So essentially, your child gets a free attorney. You don't, but your child gets a free attorney, and that is to protect their constitutional rights. I've known of cases personally where family members have horribly taken advantage of their disabled individual, developmentally disabled, robbed them of hundreds of thousands of dollars. Horrible situations to even conceive that anyone would have the gumption to take away money from a disabled adult child who has autism or Down syndrome. Is more frequent, but not pervasively, but it's more frequently you find that with senior citizens. So anyway, that's the entire process. Up front, you get a court hearing. There are some documents that the attorney needs to file on your behalf afterwards. They're called post filings, and those include, for example, confirming what the address is still the same as originally was filed with the court, notice of rights, which goes to the family members, that there was a conservatorship and it was granted. So there's lots of work to do. We have staff in our office dedicated to this particular effort, and we stay in constant communication. So what you want to make sure of, whatever law firm that you work with, that within at least 24 hours they let you know what's going on. If you have an inquiry, we're very good about that. We're a bit overstaffed to make certain that takes place, but communication with our clients is very important. If you have any questions, you could give me a call at my office, 562-699-2412. Again, we have offices in Riverside County, City of Riverside. We have offices in Orange County, Huntington Beach specifically, off of Warner Avenue. Again, our number is 562-699-2412 if you have any questions. Have a good day. Thank you for listening.